parties could unmute, I want to get a sense of, I have received filings since our last hearing. We were originally set for an evidentiary hearing. I see that there is a power of attorney signed that, although I understand there's some issues about possessions, appears to resolve the guardianship issue. So I want to check in with the parties and see what their thoughts are on this.
Well, Your Honor, on behalf of my client, the mother of Samantha, that's her position. She wants out of this litigation. She wants this litigation done. So she signed a power of attorney to the petitioner party, Tamara Coast. So Ms. Coast now has a power of attorney over Samantha, and this case should be dismissed.
Ms. Bliss.
Thank you. And for the record, I do represent Samantha, the youth in this matter. While I would agree that the power of attorney essentially gives Ms. Cost the ability to continue caring for Samantha, the issues still remain regarding the possessions. And my concern is if Your Honor were to dismiss the guardianship today, that those issues would be left unresolved and there would be no remedy to get those possessions back to my client. I did receive a filing from Mr. Anagnostu's office yesterday at about 4:30 with his client's position on returning my client's possessions, but I haven't had the opportunity to really speak with my client regarding those. But again, my concern is if we dismiss the guardianship petition, both guardianship petitions today, that those issues will be remain unresolved and we wouldn't have any remedy to get those possessions back to my client.
Okay, thank you, Ms. Bliss.
Your Honor, this is Tammy Cost.
Yep, ma'am, I'm coming to you next. So Ms. Cost, I see the power of attorney. Please give me your position on whether you're voluntarily dismissing your petition today or not.
I am not voluntarily dismissing the petition, and I'd like to clarify my legal name is Tammy, not Tamara. My family happens to have two sisters-in-law with similar first names, and I don't want my case confused with issues that Mr. Anagnostu's office has represented my sister-in-law in the past.
Have not called you Tamara.
No, ma'am.
The court filings reference you as Tammy. You're logged in as Tammy. So with that noted, please go ahead.
Okay. I agree is that property has been a huge issue, and trying to get property back has been not good. Basically, when Samantha originally arrived at my house, she had a duffel bag and a couple other items, and that was it. And we were told that we weren't going to get any other items. If my guardianship request is dismissed, then there is no recourse to get the property. There's been no communication from Ms. Gilliam that I'm aware of pertaining to how we're going to work this out. There was a comment made that she planned to drop some property at my husband's place of employment, but with not knowing how much that might be, and with that being an employment place with other employees and him not wanting to have legal matters, personal matters displayed before coworkers, we were opposed to that being a drop-off site. We are open to independent or neutral sites, and that once the property is returned, then I would submit to have the guardianship dismissed.
Well, my concern here is that I am being asked on this docket to insert myself into transfer of possessions that I don't believe the Minor Guardianship Act gives me authority over. I am happy to be wrong about that if someone wants to tell me I am wrong. But here's my initial perspective after reviewing the materials. I am willing, again, to be wrong on this if someone has authority, but my take is this was filed for emergency minor guardianship. My role is limited to whether I believe there's a parent able and willing to care for the child. Now we have a power of attorney that transfers that right. I feel as if the matter is moot. I don't think that there's an issue that can be litigated in front of me on this docket under the minor guardianship pleadings. So my gut instinct is that I do have to dismiss the petition today. That is not to say that there isn't some other forum in which possessions could be fought over, but I'm not sure it's here. I'll first maybe turn to Ms. Bliss. I know this is kind of putting you on the spot. But I know since you argued for this state in front of me for possessions, let me know how you might disagree with me, and we can then, I'll make my final ruling after I hear from the parties again.
And while you were speaking, I was trying to pull up the RCWs to determine and point you in the direction. But I do recall in my past of working in these cases, the court can make at least temporary orders or orders to the effect of transferring the minor's possessions. I would agree with Your Honor's procedural analysis of if the guardianship is dismissed, that you essentially lack the authority to continue to make orders within that. I guess at this point, I would just ask the court to make whatever ruling you're going to make, but allow me to bring this matter back before the court if I find legal authority to revise or reconsider your decision today.
Would it be helpful, Mr. Anagnosto, I'll come to you. My other thought as I was prepping this case was, because this isn't an issue I've had in front of me before, if we could get it done in short order, I'll be off this docket after next week. But if the parties wanted a week to submit briefing on this issue, I would be happy to put this on. I know holiday schedules. I'd be happy to put this on next Tuesday's docket. We only have one other case that day, to allow time for briefing on the issue of possession of transfers and whether that truly is within my jurisdiction. But so I'll throw that out there as an option.
I guess my initial reaction, Your Honor, is I agree with your first position that the guardianship statutes are just that with regards to guardianship over, in this case, a minor, or it could be an adult. They really don't deal with personal property. I'm court appointed, and I'll do research and brief this issue, but I think your first impulse is to grant the dismissal, which this case needs to be dismissed, and then that would I would submit my discharge and billing statements to get paid by the county and be done with this case. I'm looking forward to being done with it as well, and I think that's the appropriate way that we go at this point. If you want to set it over a week for entry of an order of dismissal, and Ms. Bliss can do research. I just don't think I agree with you. I just don't think there's authority over personal property, nor should I be expending, legal time briefing the issue and responding to this. But here we are.
Yeah, and I'm looking at the statute right now, looking under duties of guardian, and I just don't see, it does say under duties of the guardian, take reasonable care of the minor's personal effects and bring a proceeding for conservatorship or protective arrangement if necessary to protect other property of the minor. So based on my, again, I could be wrong. I take no ego in this, but I think all I can do today is find that continuing with a minor guardianship proceeding is moot, given the power of attorney. I am going to dismiss. I will indicate that dismissal is without prejudice if it needs to be re-raised and if parties find authority for me taking on this issue of personal belongings. But it would appear to me under 11-130-230-2B, now that the power of attorney for the guardian is in place, or for the minor by the guardian is in place, the remedy for personal effects would be a protective arrangement or conservatorship, or some other action, could in fact be contractual in nature, given the language of the power of attorney. So that's going to be my ruling today. I can prepare that order so you all don't have to appear back on the docket. Does that next week on the day after Christmas, does that work for the parties?
That works for me.
Your Honor, if I may, this is Sherry Farr, the court visitor in this case.
Go ahead.
11-130-575 allows for the transfer of property without the appointment of conservatorship in the proceedings.
Transfer for benefit of minor without conservatorship. Let me pull that up.
And that says assets or other property.
So unless a person required to transfer funds or other property to a minor knows that a conservator for the minor has been appointed, the person may transfer an amount or value not exceeding $15,000 in a 12-month period to a person, a guardian, a custodian, a financial person that receives right for a minor, may apply it only to the support, care, education, health, and welfare of the minor. Funds not applied.
I know that sounds like financial, monetary assets, but it does say under 2 other property.
It does say other property, but then when it talks about the sections under this, it has to be used for, well, the support could arguably be under support. I just don't think it's saying that it's an allowable act. I appreciate you bringing this up because, again, I've never had this in front of me. So I appreciate you pointing out the statute. I still don't think this gives me the jurisdiction to decide who properly owns or has or should control the property. This statute seems to say we will allow transfer of property under a certain threshold amount in a 12-month period. So I think that is really helpful, and perhaps that will dictate how the attorneys choose to move forward on this issue with the possessions. I am going to go ahead and enter my dismissal again. I do think it's moot as there is not a guardianship decision in front of me to make. Ms. Cost, you said you wanted to be heard. Go ahead.
Excuse me. One of the things that I needed to point out is I understand that there was a last-minute filing last night. I was made aware of that 15 minutes before the start of the hearing.
Okay.
The email by which it was sent, first of all, we had said we don't want service by email. Service was supposed to be done in person over to my husband's place of employment. And part of the reason for that is that people get our email address incorrect. Based on the routing of the email that was sent at 4:30 yesterday, our email address was incorrect, and that is why we did not receive it until 15 minutes before the hearing.
Understood. And I'll just note, I did receive that document late yesterday as well. It appears to me to be limited to the dispute over possession. I am declining to take jurisdiction over that dispute here today. So I'm going to find that, obviously, Ms. Cost, I understand your argument, but it wasn't used in my decision today. So I am not finding that there's been any prejudice in the filing to you. My ruling is really based on your filing to me, which was the inclusion of the power of attorney document that shows me that the guardianship has transferred to you and is irrevocable for the next 6 months. So that the minor is going to be with you until they are 18. Okay, I'm going to get that order issued. Is there anything else we need to do today?
Just a point of clarification, Judge, since you're entering that order today, I know we discussed a hearing next week, but we wouldn't be having a hearing next week, I imagine.
No, we will not. If you and Mr. Anignacio and Ms. Cost all decide that there is a possession issue, I guess, that you want to note on this docket and you have some authority for it being properly on minor guardianship, we do have room. We only have one case. So if I'm going to come to work the day after Christmas, I'm fine taking a second case, but otherwise no need to appear.
Very good. Thank you, Judge.
Thank you, Your Honor.
And then, Your Honor, do I have your permission to submit my fees ex parte?
Absolutely. Thank you, Ms. Farr.
Thank you.
And I believe, Ms. Farr, you're on this case also.
Yes, Your Honor.
So when we were here last, we did do a continuance. I know we have a child support order that's been proposed where the paying parent is Ms. Bornstedt. I do have that original order here. I do have also the proposed minor guardianship findings and order. And gosh, this is so frustrating to me sometimes. I still just don't see the DCYF response. And I believe when we were here last, the court sent the order again, and I still don't have it. And for me, I believe that's the only last remaining piece here. And unfortunately, I just can't find the order without it. But let me turn it over to the parties.
Your Honor, I don't believe I've seen the proposed findings. Who submitted those?
The guardian, Ms. Kulanoni. That has not been sent to you?
I don't remember it off the top of my head.
Okay. Well, unfortunately.
I'll contact her and.
Okay. It sounds like we'll have to, I think that unless the parties disagree, I think we can address child support. So Ms. Powers can be done, but I don't think that we can address the guardianship because of that DCYF order. Mr. Sasaki, any input on your end?
Yeah, I didn't see the findings or didn't receive the findings either. I can check on Odyssey later. But I believe that the matter of visitation was also left open unless addressed in those findings. And I was asked to reach out to my client for their position on proposed visitation. We did reach out to my client, making him aware of today's hearing and asked if he had a proposal as to what visitation would be, with yesterday being the deadline for getting word back from him. We have not received instructions from my client. However, on his behalf, I'd like to propose supervised visitation via a teleconference, FaceTime, telephone, something of that sort, if and as recommended by the guardian.
Okay. Ms. Farr, do you have a position on visitation? And Mr. Sasaki, thank you. I do have that in my notes from our last hearing. So thank you for reminding me of that.
I actually need to talk with the guardian about that before I can say anything further, because I know that there may be some issues with that.
And I will note, Ms. Koinoni, your proposed language on visitation with dad was released from prison, and then he would need to ask for visitation. Is that still your request of the court for the final order?
Yes, my thought was that he would have to go through family court to ask to get together everything that he needs to re-enter into his life, as far as classes. You know, I know that he gets some things in prison, but you know, it's going to be a big. He's been in for a couple of years, and he still has, I think, almost 3 years left. So it's going to be a big adjustment for him. And by that time, Hazel's going to be 5. And, you know, it's just, I don't know if, you know, I don't think that he's planning on trying to jump right in and be dad, you know, all of a sudden, or I don't think he has those expectations. I think his expectations are to take it very slow and to do what he needs to form a good relationship with Hazel.
Is there any current phone contact with the minor child and Mr. Layton? Just
between him and I, and she's around, and I send him pictures. We contact each other about once a week or once every 2 weeks, and I send pictures, you know, like that.
So would you be comfortable with language that phone visitation with you present with him is allowable at your discretion?
Oh, yeah. And I don't mind even doing video calls with him either, you know, so he can just watch her play, because she's not interested in being on video at this point.
Well, so since I have to, unfortunately, and I don't know, I'm just looking here if we. Let's do this. So for the clerk's office, can you guys go ahead and resend that order again? I'm going to have to reissue emergency order and set a new date anyway. Mr. Sasaki, I'll let you decide if you feel you need to be present. I mean, I think your advocacy for your client with the consent and the request for visitation is complete. I am going to put in the new emergency order that phone and video calls between father and minor child allowed so long as guardian is present. And I do plan to carry that over to the final order once we get the DCYF records.
Your Honor, I've even called to talk to Lisa, who is in management position now over there, left messages with her about it to you as our case manager when we first started this whole thing. And I haven't heard back from her even.
Yeah, you're for other folks on this Zoom call with their cases. It's going to be a common theme. I'm going to sound like a broken record today. So it's just something that's been real difficult to get. But Mr. Sasaki, go ahead. I think you were going to respond.
Thank you, Your Honor. What you described in terms of me discharging from the case, I have no objections with that, and duly noted on the phone call visitation arrangement going forward. I'll let our client know and prepare or communicate representation and closure of representation with their client going forward.
Okay. Sounds
Your
good.
Honor, before the father's attorney is discharged, the state is requesting a child support order against both parents. Since the father's incarcerated, we'd be setting support at $50 a month, abated down to $10 a month.
And I saw that too. Has that been, I didn't quite get as far to see if Mr. Layton had been served notice of that, but I know we've had this issue on the docket a few times, so I'm assuming the answer is yes.
Yes, we have. We sent it back to him April 6, 2023 at Airway Heights.
Yeah. And Mr. Sasaki, I'm inclined to enter this order because it is at the $50 amount. I don't, want to put you in a bad spot having to agree to it, but let me just ask, as far as you know, has your client given you instructions to object to that minimum amount?
No, there has been no objection, and I believe he's been made aware of the $50 per month. Okay. I don't recall hearing about the $10 per month, but I may be mistaken.
The order is setting it at 50, but it includes that the order's being abated, so it will be $10 a month while he stays incarcerated, and then go up to the 50 a month.
Yeah,
understood. That makes sense. Thank you.
Yeah, and that is in number 16 on his order, page 4. It does include that $10 abatement language. So I am going to go ahead and sign this order. And then Ms. Powers, do you want to go over the order for mom?
I would. Thank you, Your Honor. When we were here November 14th, the court asked me to check if there was any additional information regarding the mother's ability to pay since April of 2023. I checked employment security data, and it still shows that the last time she was employed was 2015. I noticed that DCS entered an administrative order against the mother dated April 3rd and effective January 19th, requiring the mother to pay $521 a month. The mother has made no child support payments, and her arrears are currently over $5,000. I would ask that the court enter a child support order against the mother. The standard calculation is $433 a month, but I left the whole deviation section in based on the allegations in the petition. I thought that the court might find it appropriate to deviate her support obligation downward.
Ms. Kuanoni, do you have any input on this court looking at a downward deviation of the mother's child support requirements? My understanding is, so right now we're imputing her wages, and it does then require her to pay $433 a month. It does not appear to me, based on allegations in the petition, that is something that she is going to be able to do, but I would like your input.
She won't be able to do. She was looking at trying to get into a FOSA program, or FOSA, I'm not really sure how to pronounce that, is what she said. And we'll set to have a hearing on it, I think, this next week. But she was incarcerated again last week. And so I don't know if that's going to have an impact on going to treatment or going to prison, because that was her only two options. So she's either going to be in long-term treatment or be going to prison. And no, she's very ill. She would not be able, she doesn't work. She hasn't worked for years, so.
Okay. I am going to grant a downward deviation. Ms. Powers, does the state have any input on a proposed amount, hearing what you've just heard from the Guardian?
Hearing what I've just heard from the Guardian, the state would not be opposed if the court dropped to the statutory minimum of $50 a month. It sounds optimistic that she'd even pay that.
Okay. Thank you. I am going to do that. I'm just going to write in here my reasoning for that. And then Ms. Powers, maybe you can help me. Do you, for the state's reference, need me to make that same note on the worksheet, or if I've made the change on the order, is that sufficient?
As long as it's on the order, it's sufficient.
Okay. All right. So I have signed those 2 orders and the worksheet. I'm going to hand that up. And then I think we just need to set a new date to hopefully finalize this. Ms. Kunoni, if you still have a copy of the proposed findings and orders and want to get that to Ms. Farr, that would be helpful. And, okay. And then my strong hope is that we have that DCYF response and we can get this finalized at our next hearing. Is there any proposed date?
Your Honor, I would like to set it for January 16th.
Will that work for you, Ms. Kunoni?
Yes, that's fine.
Okay. All right, I'm just going to get this filled out quickly. Just hold tight with me for 1 minute. And then we have the child listed at 1 year old. I just want to make sure that's still accurate since I know this case has been pending some time.
She'll be 2 on April 14th.
Not until April. Okay. So that is still correct. I have put in the phone and I'm going to add video visitation allowed with father if minor or with guardian present. I'll just say readdress if and when released from prison. And then I have got that. Any questions for me from the parties?
Not for me, Your Honor. Thank you.
Thank you. Okay, you are free to log off and I've got those documents filled out and we'll see you back on January 16th. And I'll
thank you.
Thank you.
I'll give you that original order. And I believe I saw Ms. Maddox online already. There you are. I did get just on the 15th, the Clark County Sheriff's return of service on dad. So that is great. It is in our file now. My understanding, I know we also have child support to address in this case. We set it over because we did want the father to be able to respond if needed, or if he was going to. It seems doubtful at this point. But also, unfortunately, I don't have DCYF records, and we did resend the order on November 21st. So let me turn it over to the parties to see where we are at.
So, Your Honor, this is Sherry Farr, the court visitor, and that is where we're at. We need the CPS information. We need to prepare the proposed findings, and I need to complete and file my report now that service has been made.
So, Ms. Maddox, we're getting closer. I know you've been with us many, many times, but we're inching along. Ms. Powers, are we hoping to address child support today?
I was sure hoping so, yes. In this situation, we are not planning to enter an order against the father. There's already an administrative order in place requiring him to pay $148 a month. I believe that that's appropriate. For the mother, we've proposed child support. The standard calculation is $415 a month. I did leave the deviation section in case the court found it appropriate to deviate downward.
And Ms. Maddox, have you had a chance to review the proposed child support obligations for mother?
No, but I'm okay with that.
Okay, so we are imputing her wage at minimum wage right now. That would result in a payment from her of, let me just get back to that section. Where did it go? $415. Where the court always considers extraordinary factors in determining what the appropriate level should be. Do you have any input on whether you are opposed to a downward deviation of that amount by the court for mom?
I'm happy with whatever you do, Judge.
Okay. Do you know what mom's financial situation is currently?
She's still living on the street with a new guy.
Okay. So much like the prior case, my proposal would be, given that we don't have any indication that she's housed or employed for the time being, would to reduce to the minimum of $50 a month. Do you have any objection to that?
No, thank you.
Okay. Ms. Powers, any objection to that?
No, Your Honor.
Okay. And then what would be a recommended date? Do we want to come back on January 16 for this case as well?
That works for me, Your Honor.
Okay. So Ms. Maddox, my strong hope is that January 16 will be your last court date in front of us. I hope that is true. Really, the only thing we're waiting on is that DCYF response. Okay, any questions for me today? Otherwise, I have Ms. Powers signed the documents for you.
I'm good, Your Honor.
Okay. All right, thank you all. You are free to log off.
Thank you. Have a good day.
Thank you. My understanding, and let's make sure we've got all the parties here. I see Mr. Reisenberg present. Thank you for your work on this case. I see Ms. Farr. I see the proposed guardians and the minor. I see the father, Jason Grounitz, here. Thank you all for being present. And I see Ms. Grounitz here. Thank you. So my understanding is we have made some headway. We have appointment of a resident agent. Thank you, Mr. Reisenberg. We have, I believe, parents' consent.
Is that? Yes. Parents' consent for the emergency portion only.
Okay. Did that get filed with us? I see it in my notes that they consented to the emergency.
I think I might have those documents and I haven't filed them yet.
Okay.
I'm just going to file them with my report.
Okay. Let me ask this orally. So, Ms. Grounitz, have you signed a document before today's date that consents to Corey and Luis being the emergency guardians for Riley? Oh, I can't hear you.
Okay. I do believe maybe I did sign something, but I think it was, I don't know if it was the emergency, the 2-month emergency, or if it was the other one, but I did agree to it.
Okay. Are you still agreeing to the temporary emergency order being entered?
Yes.
Yeah. Is that a yes?
Yeah.
Okay. And then Mr. Jason Grounitz, same questions for you. Did you sign a document for this immediate emergency order? And is that still your intention here today?
Yes. Yeah. Can you hear me?
Yes, I can. Thank you.
Okay, good.
Okay. So then we've got service done. I believe I saw proofs of service in the file. We have the consent forms, at least for the emergency order. We've got a Washington agent. I believe that only leaves me with what Mr. Reisenberg, I believe, is prepared to talk about today, is whether this court should make a finding that the criminal history of one or more guardians doesn't preclude me entering an emergency order. Does that sound correct?
Yes, Your Honor.
Okay. And Ms. Farr, any input from you before I hear that argument?
Your Honor, I'm in the process of writing my report, which was going to give you information on those criminal charges to be able to make a good decision on.
Okay.
Or I wouldn't say good, but informed.
Informed.
Sorry.
Nope, you're good. Is it something you would be comfortable orally discussing today after I hear from Mr. Reisenberg?
I'm not sure that Mr. Granowitz would be comfortable discussing in the public forum.
So it may be something that you're filing under seal.
Yes.
Okay, gotcha. Let me ask you this just briefly from an emergency perspective, immediate emergency order perspective, which so far I've declined to enter. are you able to provide the court with any input as to whether you are going to recommend an immediate emergency order despite that history or not?
So what I plan on recommending, not as immediate, but as an emergency order, is that the emergency order be put in place for 60 days. I don't believe his criminal record should preclude at this point him being the emergency guardian, and then have a review after 60 days. That's my recommendation.
Okay, that's very helpful. I appreciate that. And then, of course, when you file in writing, I will review that in more detail. So go ahead, Mr. Reisenberg.
Thank you. I would argue that it shouldn't stand in the way of a guardian, of him being appointed as a guardian under RCW 11-130-090. Upon review of the facts, the court can decide that he is an appropriate guardian. And I would suggest that the facts being that it was a fairly small amount of money 30 years ago with no repetition since, suggests that maybe this wouldn't be an issue today.
Mr. Corey Grounitz, anything else you want the court to know?
No.
Okay.
So, Your Honor, just for your information, there's additional criminal history not in the state of Washington, which is something that I need to explain in my sealed report. But I also still don't think that will preclude him.
Okay. Because we are live streaming on YouTube, I don't need details. How long ago are we talking with the out-of-state charges? Because you're right, I can only see in-state.
I don't have those notes in front of me.
Okay.
Mr. Gronowitz probably can just give you the year.
Yeah, so Your Honor, in 2016, I was arrested in Mexico. I was held in jail for 16 days. And I'll just, since Ms. Farr has already kind of made it clear to me, some of it might be sensitive, and we are live streaming on YouTube. So if you want to get, I was innocent of those charges and released. I do not have a conviction in Mexico.
Okay.
There's no criminal conviction. So anyway, so that's that. Yeah, and we go back to Mexico quite. We've been back to Mexico fairly often since. So anyway.
Okay. Is there anything in any other U.S. states as far as history? Okay. Ms. Farr, any further input before?
Your Honor, so I mean, I can have my report up to the court quickly on this one. I've almost got it finished. If you want to set the date to the 2nd of January, or even the 26th, I can have it to you this week if you want to enter it on the 26th as well. And that would give you the information that you need. But like I said, I don't think there's going to be an issue. I just think that the court needs to have the report.
Okay, let's do this. I think I've heard enough to be comfortable to enter the immediate order, which I've so far declined to do. And I can't enter the, we do have a full petition filed as well, correct?
Yes.
So I can't even get to that because we don't have, do we have the DCYF records yet?
No, but the consents from the parents are not on the full petition, just on the emergency petition.
Oh, right. Yeah. So I wouldn't be able to get to that anyway. Thank you for that reminder. So a couple things outstanding for the emergency petition anyway. So why don't we do this? Because I know the guardians have had some concerns about medical treatment for the minor. I think I have enough where I'm comfortable entering just an immediate order for emergency guardianship today. Let's go ahead and then set this for January 2nd, though, just as a review. And at that time, the presiding officer can decide whether to extend the immediate order after they've reviewed Ms. Farr's report or not. Does that sound fair?
Or possibly enter the emergency order?
Or, yeah, if we have those, yeah, exactly. So maybe we'll put it on for review and approve petition. Are you available Tuesday, January 2nd at 10:30?
Yes.
Okay. Okay. I'll set this review date for January 2nd, 2024, 10:30 a.m. Just going back to your original request, there was no request made for any temporary restraining orders, correct?
Correct.
Okay. I have that immediate emergency order filled out. So you can get a copy of this from the court. And that should help you with medical things that you were asking about at previous hearings. Anything else we need to do today on this matter?
No, I just, so on January the 2nd, what's that about?
So January 2nd, we will review Ms. Farr's report just to make sure it doesn't change whether we're keeping an immediate emergency order in place. Okay. And then if we have our ducks in a row to proceed on the emergency order petition, we will. But there are a couple more things the court would need before they could enter that order anyway. So I'm going to put it down for a review hearing and a hearing to approve the emergency petition. We'll just see how far we get based on what we have by then.
So in the meantime, we have a document that gives it to us for 60 days.
This document goes through the January 2nd hearing.
Okay.
And then at the January 2nd hearing, it can be re-upped or the emergency order can be issued.
Okay. All right.
Yeah. All right.
And when can we go by the court to pick up this document?
Let me check with the clerk. When would this one
be? If they're here today, we can hold it. And
okay.
We can come get a copy, hopefully before the end of the day.
Otherwise a couple days. Tomorrow, if you want to come today, let us know. They'll hold it for you before they put it through the scanning process, which can take a couple days. Otherwise, you could probably get it later tomorrow or the following day.
Okay. All right. Sounds good.
Do you have a preference so I can just let them know whether to hold on?
Yeah, I won't have time to come get it today. I'll come on Friday and get it.
Okay. We close a little bit early on Friday. I think like 3. Yeah. We'll be closing at 3. So try to come before then. I think they're going to stop taking numbers at 2:45. I think I saw that somewhere in some email.
Okay.
Okay.
All right.
Thank you all. Thank you, Mr. Reddick. Thank you, Ms. Farr. So I have Ms. Curry present. Thank you. And Ms. Farr, you're also on this case.
Yes.
Did we put all of your cases to today?
No, just a handful.
Do I have anyone else on this matter?
Brian Phelps.
Okay.
So, Your Honor, Brian Phelps is, he has filed a paternity test result showing that he is the father. However, he has not been adjudicated. I spent some time going through the forms with him to explain to him how to file a paternity action, but I don't believe it's been done yet. Okay. So until that's done, he's not a party in this case.
Okay.
I'm here. I mean, I would like to request an attorney because I tried to, it's all confusing for me. I'm lost with the petitions I need to get. And yeah, so I would like to request an attorney.
Okay. And let me just ask Ms. Farr, is he on the birth certificate?
No.
No.
That's why he's not a party. And I tried to explain to him that he can't get an attorney because he's not a party.
Yeah. So Mr. Phelps, this is, let me pick up something first that might be helpful. Because I do know that you appear to have a document that says that you are biologically the father and you are taking action to, number one, appear here today and hopefully file a paternity action to get on the birth certificate. I'm not going to be making any final rulings regarding your minor child, but you aren't yet a party to this minor guardianship case. So I can't appoint you an attorney here today. But please, after today, we'll set a new follow-up hearing date, but you really do need to reach out to an attorney or even the state of Washington to get guidance on how to get the document that you do have converted into the type of document that gives you legal standing in this case. Okay.
Okay.
Okay. So so hold tight with us, Mr. Phelps. I'm going to go through some other questions on this case.
Okay.
Did we get mom served yet on this one?
She was in jail, and so I was able to get the return of service from Clark County late Friday, and I filed today.
And what did you get that filed in our court yet, or not yet?
I did. I filed it yesterday. Sherry and I kind of went over some emails this morning, and I will be getting everything to her as well.
Okay. So here's going to be my recommendation, and then Ms. Farr, please jump in as appropriate. Because of what we have going on with a presumed father at this point, but not yet a party to this case, I do want to give him time to get that legal standing. I will reissue the immediate order, and we'll set a new hearing date that will also give you time to file the proof of service with the court on mom, because I don't have that yet. I don't disbelieve you. I just have to have it in the file.
Okay.
And then I still don't think on this one, we might also have a DCYF question also.
Correct. I don't think we have any CPS info filed on this one. And there was also another form that I asked the proposed guardian for this morning, the disclosure on the co-petitioner.
Okay.
And then we just need to prepare findings, but you're saying that you don't want to enter findings. And just so you know, Your Honor, it was about a month ago that I went over in detail, you know, all the forms for Mr. Phelps to file. I wrote it out very explanatory in an email so that he could file his parentage action, gave him all the form numbers.
Okay.
So, I mean, he's got that to follow too.
No, that is very helpful. Thank you for doing that. Mr. Phelps, do you have that information?
I do. It's still, it was, I mean, yeah, I was lost. It did all the petitions on there. I wasn't sure. It just made no sense to me. No fault of hers. I just don't understand it.
Understood. If you want to reach out to, I believe it's Cowlitz-Wahkiakum Legal Aid to see if this is something they help with, feel free to do that.
How do you spell that?
So it's the county of Cowlitz. So Cowlitz, yep. And then the word Wahkiakum. So the two counties, Cowlitz-Wahkiakum Legal Aid.
Okay. Wahkiakum, how do you spell that?
You can look it up, sir. It's the county most adjacent to us.
Okay. Wahkiakum. Okay.
I'll send it to you, Brian.
Okay.
Okay. Right. Then I'm going to reissue the immediate order. Ms. Farr, what would be your, well, let me do this first. Can the clerk's office resend that order? I don't think we've done it on this case yet, the DCYF order. So given that, I'm thinking at least a month out, but maybe even further. What would be the recommendation here?
You think the 23rd is too soon, or do you want to go out farther?
Why don't we do, well, that is about 6 weeks, isn't it? Is that 5 weeks?
It's just over a month.
Let's go to that last Tuesday in January, just given, I know it's frustrating to me to come back here and have to tell people I can't help them because we don't have DCYF records. So maybe we go out a little bit further.
Your Honor, I'm not going to be available on the week of the 30th. Okay. But the 6th would be the next available date after that of February.
Ms. Curry, would February 6th work for you?
Yeah, that works.
Okay. So Mr. Phelps, oh, go ahead.
I know that there's some things that Sherry and I need to figure out as well.
Yeah. Okay. Do you want a sooner review date than that, or will that work for you?
No, that'll work.
Okay. So let's go to February 6th. And Mr. Phelps, at that time, if I have everything else in order, we may move forward on this case. So I really would implore you quickly to get your documents filed so that you do have legal standing in this case. Once you do, I can appoint you a lawyer if you're still requesting it. So the sooner you get that done on your end, the better.
Okay.
Okay. Okay, I'm going to get this signed. Any questions for me on this case?
What time is the next on the 6th?
10:30 a.m.
Same time. Okay, thank you.
And then how old is Lila now?
She's almost 4 months.
Almost 4 months? Okay. Okay. All right, I've got that reissuance through February 6th, 2024, and I'll see the parties back at that time.
All right,
I'm glad to bring up the court to speed on where we're at, if you wish.
Please do. I'll turn it over to you.
Okay. I believe we have an agreement to resolve the case, although procedurally we're not ready because we don't have the right documentation in place, like i.e. the petition for minor guardianship. So we've agreed, according to Ms. Day's guardian ad litem report, my understanding is the parties have accepted the residential and visitation plan that is in her report. So I've drafted an order on emergency minor guardian. I just finished it this morning, and the way it printed out was horrible.
Of course.
So, but I did circulate that to the parties, and I think if we want to set this over a week or two,
okay.
I'll leave it up to the court's discretion, of course, but it just depends on when Miss Rowland can get the petition for minor guardianship filed. Okay. And then we're going to be right back with the final order at that point. So I think that's where we're at. Okay. So,
any input from the other parties based on what Mr. Esau has stated?
Miss Rowland has emailed me her summons and petition for the full guardianship, so hopefully she can get those filed today. I hope they were sent to Mr. Esau as well, but I agree. It sounds like the parties have come to what is a good resolution and meets the needs of this child and provides for her. And probably 2 weeks should be sufficient to get this all done and entered.
Okay.
May I speak to Tina for a second? Tina, I sent that and I'm glad you got it, but there's 2 other pages and I can't seem to figure out how to get those to send. I have them done. I'm not computer smart. So I'm going to try to get some help with that later and get those other 2 sent to you, and then it should be done, right?
We can talk off the docket, but you need to file it with the court.
Oh, okay. So yeah. I just have to go, once I send it to you, then I go down and print it off and give the court a copy.
Correct.
Okay.
Okay. So then let me ask, is there an agreement for me to extend the immediate emergency order through the January 2nd hearing date?
Oh. Yeah, we could do that, Your Honor.
Okay. Yes, Your Honor.
Okay.
I did fail to mention one thing, and that is I don't believe the lay guardianship training has been completed by the petitioner yet. So I will probably address that in a couple of weeks, but I forgot to mention that.
Okay. Ms. Rowland, have you had a chance to do the lay guardian training?
I'm not even sure what that is.
Okay. Why don't you? Yeah, so that would be a no. So reach out to Ms. Day after docket. We will need proof of that.
Okay.
Okay. And then the minor child, is she still 9 years old today?
Yes.
Okay, make sure I've got everything on your order filled out. This just extends the immediate order through January 2nd, 2024 at 10:30. Thank you to all the parties for working diligently on this. I'm just going to indicate we're still doing visitation as per the 1128 order, which allowed unsupervised visits every weekend if prearranged with the guardian, and so long as a specific individual is not present. Is that correct?
And what? Okay, so say that again. I misunderstood.
Sorry. So what I wrote in the last order was that mothers allowed unsupervised visits with minor child every weekend if prearranged with the guardian, and so long as Brianna Bullock is not present.
Yes, that was the original agreement.
And is that still going to stay in this order?
I would like it to, but it's up to you. You're the one that's calling the shots. So
sure. I'm just asking if there's an objection to that. If we're
no.
Yes, I would object because we do have an agreement for a more expansive visitation plan, and I didn't in my proposed order. I laid all that out for the parties because it provides for a Christmas vacation, for example, starting on the last day of school at 5 o'clock until 12 o'clock on Christmas Day. So I suppose under this proposed immediate order extension, if the parties agree that we'll just follow the agreement, then we can probably get away with just using the immediate order as an extension. but I wanted for my client to have the benefit of the agreement going forward until the next entry of the next order.
Yeah, sounds like the only difference will just be some additional days this week leading into Christmas, since the 23rd and 24th are holidays anyway. And it looks like if the GAL's report is an accurate reflection of the agreement, it's winter break, first half with mother, beginning the day school dismisses at 5 p.m. until 12:25 at noon, and then the balance of the break with petitioner.
Yes, that's the way I understood it.
Yeah, yes.
Okay. Why don't I put that language in this immediate order just so there's no confusion? That gets us through this holiday period. And then obviously once the agreement's signed, that's going to dictate all the future.
Right. Okay. Very good, Your Honor.
Okay. Let me just get that written in real quick. And I'll just clarify, this is pertaining to winter break 2023. First half. What day does school get out? Do you want me to put in a specific date, or?
It's already out.
Was it out on Friday?
Yes.
Okay. So is child already with mother?
No, she's with me because this order hadn't been. Also, mom gave me permission to keep her till tomorrow because she has dance class tomorrow, and it's only for an hour, so it's ridiculous for her to drive up here just to spend an hour and drive back.
So what if if the language says winter break 2023, so it's only going to pertain to this year, first half with mother beginning Wednesday, December 20th by 5 p.m. and then going through Christmas noon.
Yeah, that's fine.
Mr. Esau and Ms. Betters, does that work for you?
Yes, Your Honor.
Yes, that works for me. But I wanted, so the reason I was asking about like reviewing before Christmas was because of family events and like Brianna Bullock being present. And I don't see a reason why she couldn't be with Brianna as long as she wasn't in a car with her or alone with her, I guess.
Ms. Rowland, what is I haven't looked enough to see if Brianna is addressed in the agreed order at all.
That would be fine, as long as my theory is that there's extra time if you're going to be dropping her off to spend the night somewhere or whatever. I just want to have that option to have that time back. And Brianna is the reason we are here doing this. So I'm concerned, but if Christy's going to be there, that's fine.
Okay. And then, so I will put, except that I'll say Brianna may be present so long as mother is present. Okay. That should get you through to January 2nd. And then you all can enter your agreement that will void this out and take over.
Thank you.
I know I saw Michael Vorse. I saw Katrina Vorse, the mother petitioning. I do know we have an observer. Is anyone else here on this matter?
Yes, Your Honor. I'm Jack Carnahan. I am Jessica's father.
Okay. Thank you both for being here. So I know I had a few of these parties on protection order docket yesterday, and we kind of all talked about letting this go first. So we are here. I have not, I don't believe, had this case in front of me yet. I think it's primarily been with a different judicial officer. I did go back and review the notes, and it looks to me like the petitioners, after filing their show cause matters, did have a date set for a decision on the order on the emergency minor guardianship on January 4, 2024, which will be the first Thursday after the new year. So that's on the calendar. What I have in front of me now, though, appears to be, number one, Ms. Vorse, the court did receive your objection, but number two, you have noted on a petition to terminate the guardianship. So my understanding is that we are here, Ms. Katrina Vorse, on your motion to terminate the guardianship.
That's correct.
Okay. So I don't see that we have any, but correct me if I'm wrong. Has anyone been appointed a court visitor or a GAL in this matter?
Not that I'm aware of.
Okay. And then I had a question. I believe, let me double check my work here. Is Mr. Carnahan on the birth certificate?
Yes, he is.
Okay. Has he been served with this petition?
No. Well, he was with me when I did the petition, but he hasn't been served anything.
No, sorry, Ms. Vorse. I mean the underlying minor guardianship. So now I'm talking to Michael Vorse, the guardians, the proposed guardians. On the underlying petition, I saw that you originally had listed Mr. Carnahan as the father, but then you crossed it out and wrote unknown.
Yeah, that was as it is unknown. We've had conflicting reports, even in from what Jack Carnahan told the doctor and to what they both told the sheriff's office, and then another statement by another person where they're moving in now that his son was the father. So we don't know. Jack told me that he was going to get his name put on the birth certificate. So I don't know when that happened, but he just told me that probably a month ago.
So is there a birth certificate with Mr. Carnahan listed as the father?
Yes, there is. I just don't have a copy of it yet.
Okay. We are going to need that because that is going to dictate whether the court can move forward on the underlying guardianship.
Okay.
I
have the piece of paper that states that the Olympia sent me saying that he has been put on it.
Okay. Well, we'll need the actual birth certificate though.
Okay.
So let me ask you this, to the current immediate emergency guardians, are you objecting to termination of the guardianship?
Yeah, I'm objecting to it. Yeah, it's not best for justice.
Okay. So my thought here, Katrina, I am going to hear from you in just a minute, but on the underlying, gosh, there's so many potential issues with this case. You all are not going to be ready for a hearing on January 4th unless we get someone involved. So first of all, I do believe just on the underlying matter, we need to appoint a court visitor. That person can help with service issues, with birth certificate issues. They can also file a report with this court as to their recommendations regarding whether there is a parent able and willing to meet the needs of this child. So I am going to appoint a court visitor. The court will let you know who that person is. How old is Jessica?
2.
2? Okay.
Yes.
Okay. We'll assign a court visitor. Just going to fill that out quickly. That'll at least keep you all moving forward somewhat. The other thing, Ms. Vorse, at least at this point, until we know that Mr. Carnahan is a party to this action, I can't appoint him a lawyer, but I can ask you if you would like to be screened for a lawyer in this proceeding at no cost to you, depending on your current income.
Yes, please.
Okay. So tell me what your current income is.
I get just under $1,000 from Social Security and
Okay.
SSI.
Okay. And is that income or medical needs-based program?
I get SSI and SSDI.
You do. Okay. So I am going to find that because of those benefits, you do automatically qualify for a court-appointed lawyer. I will assign you one. And also you will get that person's name. So our judicial assistants take my order. They call around with the names of the parties involved. So we make sure we get an attorney appointed to you that doesn't have a conflict. And then they will reach out to you with that attorney's contact information.
Okay.
Okay. So because I'm going to appoint a court visitor and a lawyer, my recommendation or my first thought is to continue, not make a ruling on your motion to terminate today, but just continue this all to January 4 so that you can have an attorney present with you at that time.
See her.
What?
Can I see her? They have denied me visitation for no reason whatsoever. They were not a part of her life until they took her from me.
Okay, so 2 things we can do. Number 1 is you can tell me, nope, I want to move forward without an attorney on my motion to terminate, and I can take testimony from you and make a decision on that motion. Or if you want to wait and have an attorney present on your motion to terminate, what I can do today is address visitation, but keep the temporary order in place until January 4th. I would say you will be best served having an attorney present during an evidentiary hearing. So I'm not going to make that decision for you, but I'm trying to tell you what I believe most people would do in this situation. But I'm happy to address visitation with you without waiting for a court-appointed lawyer.
I just want to see my daughter. I mean, I haven't seen her in almost 2 months.
Okay. So let's start down this process of visitation. So Mr. Vorse and Mrs. Vorse, well, everyone has the same last name. Let me say Carla and Michael. I mean, no disrespect by using your first names. I think it's just going to be better for the record. Right now, you have a temporary restraining order in place where Katrina would be unable to come to your home and is not to go to the daycare or school of the child. My understanding is this is a pretty recent placement, and up until that time, the child did have regular contact with mother. So are you objecting to some form of visitation at your home or some other location between Katrina and the child?
I think it'd be fine as long as it's like you had a court-appointed supervisor. Just really.
Well, we don't do that. We don't have parental supervisors.
Some kind of third party.
Do you not want it at your home?
No,
I'm not allowed there.
Because they showed up and wouldn't leave. They have to trespass off the property.
Okay.
Made threats to me, as you might have seen in some of the things that I filed. He said he was going to make me pay for this. So I know just because of their attitude towards it. Yes, we did have professional opinion that it would be best for Jessica, and I will tell you, she has made some. She's doing very well. And I did send pictures to Katie of her getting the cards where she finally sent the cards. But
do you
like to have somebody else outside of the home?
Okay.
Who can watch and monitor, and they don't come back and accuse us of anything that I just don't want it. They've made it so difficult.
Is there a third party that everyone trusts, like a family member, a cousin, an aunt and uncle, a grandparent, someone, a friend that you all trust that could be present for visitation? And this is just for 2 weeks until Katrina, you get a lawyer and you can actually argue your motion.
What about the CPS worker that's been working with her?
My CPS case is in the process of being closed.
But I mean, Naomi, is she available? And is that something that she would do?
I don't know, because she said that she was closing out my case.
Yeah, I can't mandate a government worker to do that type of work. Now, parents can pay for a third-party supervisor, but that does cost money, and it does not sound like that's something that Katrina is going to be able to afford. So that's why I'm asking, is there a person that doesn't need to be paid? It's not their job. They're doing this to help you all over the next 2 weeks that would be there during visitation.
Your Honor.
I hate to put honestly, I hate to put anybody in jeopardy, like even other family members. Katie's made some very ugly remarks about family.
Well, Katrina, you're the one asking for visitation. So who are you proposing?
Sorry.
Who are you talking about?
Michael, hold on. Michael, stop. Michael, Katrina, please go ahead.
Well, I'm currently staying at Jessica's grandmother's house. It's not her biological grandmother, but it is her grandma.
Since birth.
Since birth.
I don't know what that means. It's not her. Who is this person?
Sandra Galster.
Right, but you're saying it's not an actual grandma, but it's a grandma. How is she related to Jessica?
She's not related. She's a step-in grandma, meaning that she's taken on the role of grandma.
Okay.
Since birth.
But I'm currently residing there, and she said that we can use her home and that she'll go and get Jessica. And there's no criminal history with her.
Well, I don't know that. So I'm Michael, and I'm apologizing. I'm going to blank. Remind me your first name, ma'am.
Carla.
Carla. I almost said Carly. Carla. I see you shaking your head. Do you know this individual?
I know of her, but Naomi, the caseworker, just texted me.
I can't hear a word you're saying. You're cutting out.
She said that Naomi, the caseworker, said that she would, if need be, I'll pay the cost for her to be in. She is a professional that knows what to look for, and I would rather not put any of my family in. Sandra, she sounds like a nice lady. I've talked to her a couple of times, but I'm not ready to go there from what.
Okay. Let me just confirm. So you said, so Michael and Carla, you have received a message that Naomi would be available to take this role on for the next 2 weeks.
Yeah.
Okay. So that would, Katrina, what's your thought about that?
I just know that Naomi's busy, and I haven't heard anything from Naomi. Last I heard is that she was closing out my case.
Okay, so
well, I don't have that text message, so I can't confirm that.
I'm not asking you to confirm it. I'm asking if you agree to that.
Yeah, I guess.
Okay. So here's what I'm going to do also then, because I do, Katrina, want you to have a lawyer present. I want Mr. Carnahan time to file. You're going to want to file the birth certificate with Mr. Carnahan's name on it well before the January 4th hearing.
We'll have it in by the end of the week.
Okay. I'm just going to extend the immediate order. Nope, it's already extended. So it's actually already goes through 1/4. So the only new thing I am going to do is issue, and I'm going to do a new order that adds, oops, where did his order go? Supervised visitation.
I don't know.
Between mother and minor. And you'll, so Ms. Katrina Vorse, you'll need to reach out to Naomi to arrange times that work for the two of you for that supervised visitation.
She's texting me right now.
Yeah.
Okay.
Yes. Can I ask something else to be added to the order?
Just a second. Let me finish where I'm at.
Okay.
So then the stay away provision is going to be modified just to the guardian's home, workplace, or school. I'm not including the minor in this at all because we are allowing supervised visitation. So I am going to make that change. Okay, Michael Vorse, what did you want to talk about?
I wanted to add Jack's name to the restriction order. To the
He's not a party yet to this case, so I'm going to decline that.
Okay.
I don't have jurisdiction over non-party because your petition indicated the father was unknown. So I need to have Mr. Carnahan file proof that he's on the birth certificate, and then he will need to be served with the original petition if he hasn't already been served.
Oh, he hasn't.
So how will I know when that happens?
I'll file a response.
We'll file a response.
It will be filed in the court record.
So I mean, when that birth certificate is filed, then how will I know that it's filed and then to be able to have him served?
Well, you can call the clerk's office and find out what has been served in the file. Also, I would recommend that Mr. Carnahan serve that birth certificate on you if he's asking to be a party to this case. He also can file an objection. He can note that he hasn't been served. I mean, essentially, sir, it's incumbent upon you when you file these petitions to determine who the legal parents are that need to be served. So you're going to have to do a little work.
Well, the day we picked Jessica up, Katie told the cops that Jack was not the dad.
How do we know?
I mean, just because they paternity test?
Just because they changed.
All right, folks, stop.
Okay.
They have been asked to file a birth certificate. You have filed a petition stating the father is unknown. Both of you have some work to do, obviously, because you're each telling me different things. Both things can't be true. So you all will have to bring that forward to me. That's not for the court to figure out. That's for you all to figure out. You're asking me for a decision. Bring me the information. I'm not going to tell people how to file information. I can't give legal advice. When you file these actions, you have to do your research as to what the court needs to give you what you're asking for.
That's
so I have filled out a new temporary order through January 4, 2024. With the new visitation, I am going to appoint a GAL. We are going to get also, I'll have to get that order after docket. We're going to get an attorney at Ms. Vorse's request.
And Your Honor?
Yes, ma'am.
I was just going to let you that we will have that birth certificate ready to file tomorrow.
Perfect. So. Go ahead and serve that on Michael and Carla so they know that that you have filed it and that they can then make sure that their petition is served on Mr. Carnahan.
Okay.
Because otherwise you're all going to come back here on January 4th and the judicial officer is going to say we can't do anything because the father hasn't been served.
Okay.
All right. Thank you all. We'll see you back on January 4th.
Yep.
Thank you.
And then 208.
I'm not off yet.
When I reviewed this one, and I know we were together recently, and I found at least on an emergency basis, because of some health issues, I'm finding that we have jurisdiction over the child, even if there potentially is an action pending in California, but it didn't sound like there was. But since we were all asked, I did see that a birth certificate was filed with the father's name on it. And I'm not sure, sitting here today, I made a note saying, Dad's on birth certificate, he needs to be served.
Yeah, I submitted paperwork to him. I actually was able to locate him and sent a packet for service down to Marion County Sheriff's in Oregon.
Okay.
As he is currently institutionalized in Oregon State Hospital.
Gotcha. Okay.
They have cashed the check, but I have not received the proof of service, and that's been about almost 3 weeks ago now.
Okay.
I actually was able to speak with him on the phone and let him know who I was, what my intentions were, and he was at least verbally agreeable at the time. And that would have been, I think, the 29th or 30th of November I spoke with him.
Okay. So it sounds like we still may need to wait for the proof of service. Ms. Farr, I know you were just recently in the last few weeks appointed as court visitor on this. Any input on your end at this stage?
Your Honor, I've reviewed the file, but I have not had contact with the proposed guardian or the petitioner yet.
Okay. And it sounds like we have, now that since we appointed you, we do have confirmation that there is a father listed on the birth certificate that appears to have been served. We'll need to wait for that proof of service. So the only thing I could do today is just set us a new date, have time for those documents to come in.
I would like to go out a little bit further if you don't mind, because I'm still having a hard time serving my ex-wife. She won't even tell her family where she's at. Last I knew, she was in Del Norte County, and I sent a packet down to the Del Norte County Sheriff's for service to the last known physical address she had. But since then, she's been arrested, booked and released down in Kern County, California. So she's kind of everywhere.
Okay.
I'm having a heck of a time trying to serve her.
Okay. Well, you're making some headway. Like I say on this docket, it's like inch by inch.
Amen.
Why don't we go out? I mean, we could do a month to January 16th, or we could go further out than that to January 23rd.
January 23rd would work for me.
Okay. And Ms. Farr, that's a date you are available, correct?
Yes, that works.
Okay. So we'll reissue the immediate emergency just through January 23rd, see where we're at that time. Give me just a minute to fill this out in case I have any questions. And is Angelique still 9?
Yep, for about 2 more weeks.
Oh, okay. So we'll have to change that at the next hearing.
Yeah.
And Ms. German, if you will call my office so we can set up a time to get in touch?
Yeah. Do I just find it on the Cowlitz County website, or how do I?
I can give it to you right now.
Okay. Thank you.
Okay, I have this order completed. Anything else we need to do on this case today?
I don't think so.
Okay.
No, my side.
Right. Thank you. We'll see you back on the 23rd.
Thank you for your time.
Mother on the line.
Yes, ma'am.
And then I have the guardian, I believe.
Yes, ma'am.
Okay. So one of the questions I had was about service. And the mother is here. Ma'am, Rachel, did you receive the petition and documentation regarding this case, or were you just told about it?
The grandmother let me know about it. I live in Oregon. She lives in Washington.
Okay.
But I'm on board with this. I placed him for Danielle to be his guardian.
Okay.
Yeah.
So you are agreeing to it. We will need to get an actual consent order signed from you.
Okay.
Let me ask you this. Do you, you are here today and you're telling me that you consent to it, but the consent form typically states that you've had a chance to talk to an attorney if you choose to do so. Would you like to be appointed an attorney to go over the consent form?
No.
Okay. And then is there a father on the birth certificate?
No. On the birth certificate, no.
There is not?
No.
In the petition, it lists a Stephen Alexander Santoya.
Yes.
So is he?
Stephen is my son, but he's not on the birth certificate. He refused to sign any of the paperwork.
Okay. So are there any legal proceedings establishing him as the father?
No.
Not that I'm aware of.
We probably will need a copy of the birth certificate. I'm trying to remember if it got filed, just to confirm whether he's on there or not.
Okay.
So maybe before our next hearing, go ahead and sign that. And then we'll just need to make sure Rachel gets the actual petition. So she'll need to get served with that.
Okay.
And there is a consent form. And I believe since you are declining an attorney, that's more than fine. I'm just debating whether. I think I would like to appoint a court visitor. The court visitor can help facilitate service on mother. The court visitor can help confirm for the court that there isn't a father that needs to be served, that there's no father still standing. And then the court visitor can also make sure that the mom understands the consent form. We typically do court visitors just at county cost. It's not an additional cost to you. It's just a person who's able to help with the case.
Okay.
Ma'am, guardian, do you have any objection to me assigning a court visitor on this case?
No, I do not.
Okay. I will fill out this order, and then when the judicial assistants decide, we have a list and we just put the next person from the list on there. They will let you know who that person is and their contact information. And then I will extend your immediate order through the date of our next hearing. I know the holidays are coming up. Because mother is orally consenting to this, I don't have any heartburn about setting this a little ways out so everyone can get their ducks in a row.
Okay.
Would January 23rd work for you all? Gives you about 5 weeks.
Yes, it does.
Yes.
Yes.
And I'll just say these dockets aren't usually this long, so I would assume your case will go a little bit quicker when you're here next. And then how old is Ambrose?
He's 2.
2, okay. And the legal name is Ambrose. I said January 23rd. Is that correct?
Yes, ma'am.
Yeah. Okay, thank you all.
And that's going to be at 10:30 as well?
Yep. Mm-hmm.
Okay.
Okay, so we'll get court visitor, and then Right now, for the guardian, in your just ex parte order, you did indicate that you wanted Rachel. The only restraining order you requested was that she not take the child out of out of Washington State. And then you indicated that the child was to live with you until all legal matters are resolved. Is there any visitation with the mother that's occurring or no?
Yes.
As much as I can.
As much as she can, I take him to visit with her.
Okay, so the only we're going to keep in that, and I think, ma'am, Rachel, you gave me a different last name than the one that I have. Are you then? So mother is allowed visitation to be coordinated between guardian and mother.
Yes.
Okay. Great. Thank you both for working together on that.
No problem.
Okay. Anything else we need to address today before you all come back on the 23rd?
Not that I know of.
Not that I know of either.
Okay, great. Well, thank you both for your patience. Thank you for being here. And we'll see you back on the 23rd.
Thank you.
All right. Thank you.
Thank you.
All right. Bye.
Bye. And then I think that ends docket. Am I missing any?